That's the benefit to the client. They don't have any risk in this at all. Okay, they're hiring us. They're getting our time and whatever expenses. And if it goes south, they're not on the hook for any of that.
So the clients get the benefit of having someone, a professional, to investigate and to set them up with the treatment that they need and get that going while the investigation is ongoing, to look into the legal matters involved, to look into the coverage involved without having to pay up front to hire someone to do that.
We get this a lot with potential clients is they say, oh gosh, you get 33% of the settlement pre-suit, and then your fee goes to 40% if we go to trial, and then if we have to take an appeal, it goes to 45%. Well, the reason being for that is simply risk. We're investing in this case, and oftentimes we are paying for experts, general costs of the file, our time, and sometimes paying for medical expenses. So we're investing in the case with, potentially we're hopeful that we get a recovery in the favor, but sometimes it doesn't always work out that way. I've had several over the last 20 plus years of doing this. I've had clients that would pass away, clients that disappear, and so you're putting all your faith, hope, and trust in a client, and you're taking on that risk, and you're hopeful that you get a recovery in the client's favor, but it doesn't always work out that way. So it's no different from you going into the bank and, hey, banker, I want to take out a loan. Well, the banker is going to want some kind of, that's a huge risk to the bank. How is the bank going to protect themselves from that?
Another thing that sometimes happens that's really unfortunate is that after we get into the case and we start investigating and doing the legal work on the back end while our clients are treating for their injuries, we find out that maybe the client was partially at fault, or maybe they were more at fault than 50% at fault,
or a coverage issue.
Or we find out that, and this happens often, especially in Louisiana, we find out that the driver was an excluded driver, or that their insurance had lapsed. Even though they presented an insurance card at the scene, their insurance coverage had lapsed, and so there's no coverage there to be able to pay our client for their injuries. And so those are just some of the types of risks that are involved, and that's why we work on contingency, and every law firm does too. That's why we work on contingency, to be able to allow our clients to have their case investigated and go through the process of, on their end, of a healing, while we figure out if they have a case and how strong their case is.
And during that time that we're investigating, we're spending money on the case. And if it goes south, we're not calling the client up, hey, you owe us money, we investigated your case, but it's not a good case, you owe us this money back. That's the benefit to the client. They don't have any risk in this at all, okay? They're hiring us, they're getting our time and whatever expenses, and if it goes south, they're not on the hook for any of that. If we didn't have this arrangement, the contingency fee agreement, then it would require potential clients to go into a lawyer's office and pay that lawyer for services by the hour. And most people are not going to have that money to do that. And these fees would escalate, and it really will prevent clients from seeking justice for their case. So this is what has allowed clients to get their day in court, so to speak, where they don't have to worry about advancing or paying for costs to an attorney's, paying the attorney's bill each month. They don't have to worry about any of that. So there's really no risk for the client. Now, the flip side, the attorney, the law firm, is taking on the risk. So we have to do a good job of vetting these cases to make sure they're good cases, because we are putting our efforts, our time into it, as well as cost into the case. Now, another thing that we get once we send the client the contract, they will look at the fee arrangement, and oftentimes I refer to it as sticker shock. Like when you go buy a new car, you're saying, oh gosh, I want this particular car, but I want to go look at it on the window, it's this number. And they're like, oh wow. I don't know how many times that I've had clients you know, they're so scared. And I learned this after the fact, to call a lawyer because they think they're going to be sent a bill. No, call me up. I'm not going to charge you for anything. I'm not for talking to you, because it's a different type of practice than you would do at like a transactional lawyer, right? But they still equate, oh gosh, I'm not going to call a lawyer because I'm going to get a bill.
Again, our fee comes out of whatever we're able to get for you. And so there's no harm for you in calling us and just getting an honest evaluation of whether it's worth continuing to pursue. And at any time during the process, if we're looking at it and we say, gosh, we're learning more and more information that's not great, we will talk to you about that and we'll let you know. And together we will make a decision as to whether or not to go forward. And even still at that point, you still don't owe us anything for the time that we've invested and even the money that we've invested into the case.